Well, hello, my beautiful people. I hope you have been well. We have been on healing mode with my Jack Russell boys. Well, and his name is Jack, Jackie Moon. And so in that, I fell down the Karen Read, Officer John O'Keefe rabbit hole. And so with my Jack Russell boys.
Hold on just a minute.
Well, and his name is Jack, Jackie Moon. And so in that, I fell down the Karen Read, Officer John. Sorry about that. Give me a minute. I didn't realize I was looking at the poll that would start playing for us. Mama D, you're my hero. Why is that, Debbie? This is going to be interesting. In the last few days, I fell into the Karen Read rabbit hole, as I said. And so this is like a crash course in the sense that we're going to hear what the prosecution's saying. We're going to hear what the defense is saying, what the claims are. What is this case about? And it's going to be a pretty short little 1 hour catch us up. There's 1,000 things to know, but we're not going to worry about the 1,000 little details. We're not going into, as they say in the courts, granular detail right now. We're just going to hit on the bare minimum, okay? So I want to welcome all you beautiful new faces as well as those welcome home that are returning. This is an all-star panel today, and if you are watching replay, I want to say humbly thank you because you guys feed the algorithm. And when you leave comments or you like it, you are saying, yes, I support this. This is worth my time. And I want to let others know. So I appreciate you. And if you are watching the live, feel free to comment. This is an open forum. I'll grab random comments to share with everybody. And it might be yours. Hi, Sue Pickett. Now, if you are watching replay, remember you have a fast forward button at your discretion. Hi, Heaven Reigns and your beautiful butterflies. Love you, Mama D. I love you too, Heaven. I love you very much. Hi, Jessica C007 or 007. So excited for this. In my opinion, Karen is an innocent woman and is being framed. All right, you guys. Let's dig into this because there's a lot to cover, and I want to get right into detail. Fair use disclaimer. Say it with me, you guys. Under Section 107 of the Copyright Act 1976, allowance made for fair use for purposes such as criticism, comment, news reporting, teaching, scholarship, and research. Fair use is a use permitted by copyright statute that might otherwise be infringing. Thank you so much. Let's get that out of the way. Now, I'm just going to play this little thing that, let me see, where do I have it? Uno momento, my lovely Luz. I'm just going to play this little background thing. It's a loop. And kind of talk about this for a minute and kind of bring you in because some people barely even know the name Karen Read, like myself. I didn't even know who Karen Read was. So she is a professor and she of a college, and then she also has a financial influence of some sort or job. Okay, so who is John O'Keefe? This was her boyfriend. So this is Karen Read on your screen. She's a professor and she's dating a gentleman who happens to be a police officer, and his name is John O'Keefe, and there is alluding to trouble in paradise of infidelity on all different sides. I'm not really into that right now. I just want to understand what this case is about. And the question that's at hand, is this accidental, intentional, or is this police corruption? So we're about to get a crash course. I don't know the answer. I don't know who does, but trial starts on Monday, and my job is to try to catch up enough to understand what is going on so that I can kind of process the information. So hopefully I do a good job in providing kind of a very skipping a rock across the ocean of the case, right? Hey, Nettie, 16 months as a starlight seed. Thank you, and I love you too, darling. She loves everyone. Hey, riding solo. Hello, Rondi Potty. Potter and Nettie. Rondi, I will get your mystery box out as soon as I have some free time. I've been kind of hanging with my Jack because he got neutered and he's on a second day or so, and yeah. But I will get it ready for you soon. Okay. So that's the biggest question. Is it an accident? Is it intentional? Is there corruption? And so I felt like we should first start with just some real basics that are like a big issue in the case itself. So an autopsy got performed, and in that, one of the biggest, let me see where I've got this. How did I do this? I opened this up in pictures. Okay. One of the biggest discussions is the injuries that could have occurred. So when you look at this case, it involves the two of them, KARENREAD and John O'Keefe, going out on a date where they're going to meet multiple people and go to multiple locations. And indeed, they are going to drink quite a lot. Well, at least from my understanding, I don't do legal terms, but it looked about 5 to 9 drinks, somewhere in there. Okay. In a very short amount of time, approximately like an hour and a half, that the driver, who happens to be Karen in this case, would have consumed. I do not know how many drinks John consumed, but we're focused on the driver right now. So, in an hour and a half, we're going to hear all kinds of information about what her levels are in trial and all the granular details. Right now, I will give you the non-technical term is I personally would be sloshed and I would never drive. But that's me. So I don't know. Maybe she's used to drinking and this isn't as much for her. Couldn't tell you. She gets behind the wheel. She has her passenger, which is an officer of the law off duty, and his name is John O'Keefe, and that is her boyfriend. Like I said, they've had a, kind of a volatile relationship, if you will, in the sense that you hear of different arguments in front of people, and there's some texts and all kinds of stuff. Well, there gets to be an after bar party, which happens to be at some fellow boys in blues, in other words, law officers' house. Okay? So Karen decides to continue her drive to that home, but she does not stay for the party. She is alleging that she dropped him off and left and he didn't come home. Okay? But the prosecution is alleging that she backed into him. Now, this gets absolutely crazy because what you're seeing on the screen here, let's click it over one so you get a better view, are the injuries. Now, if she backed up into a human being, would the injuries during the autopsy conclusively align and match with being hit by a car? Well, that's where we're at. That's what the big fight is about. The defense is saying no, and the prosecution is saying yes. Now, it even gets much more muddy because federal investigation snuck into this somehow and is in the back wings of this whole thing. So they've been completing their own investigation because the defense is alleging that this party at the Boys in Blue went awry and they may be responsible for John O'Keefe's death and have put him there as like a planting to frame her, Karen. Okay, it gets crazy sounding, but it's going to work out. So either we have 3 ways this could happen. Karen Reed left a whole bunch of icky, negative messages after he doesn't come home. But would you do that if you intentionally hit someone? So could it have been an accident? Could it have been intentional? She's mad, so she backed over him, right? You know the old saying, I ran into my ex and I backed up too. I mean, it could have happened, right? Or maybe she's so slow she didn't know she hit him. Or maybe there was motive for someone in that house to set John O'Keefe up, take him out, right? However that happened, and then put him where the blame would fall onto his girlfriend who was sloshed, in my humble opinion. So that's the crux of it. So what you're looking at here, and I mean, this is only part of the injuries, and it happens to be the right arm, I believe. The defense is alleging that this could be actually a dog attack. Now you say, well, how could a dog leave those striations and all those marks and so forth? Well, I went and got a clip from Melanie Little, who's an attorney at law, had Garrett Wing, a professional police dog trainer type individual. I say type, that's what he does, where he will tell us all about it. Okay, and what he thinks. I also grabbed a lot of footage. So I think it's time to just move into this and how I got sucked in and began to understand the case, because there's a lot to unpeel. But let's take a minute and let's just say Jennifer Koppenjapper is in this clip. And she gets the last word, she thinks. But even if Karen Read is completely guilty, I have such a hard time listening to Jennifer Koppenjapper because, I mean, wait till you see the stuff I show you after what she says. So pay close attention to all that Jennifer claims, because Melanie is making very good sense here. Now, I don't know who's guilty and who's not, but logic is that if they get rid of the dog and they get rid of the house and they change the basement floor and all this at the exact time all this is being investigated, red flags are going to go up no matter what, right? I hope I'm making sense. Okay, Jennifer Koppenjapper, take it away.
Okay, all my guests back with us, Melanie Little, Peter Ellikin, and Jennifer Koppenjapper. Melanie, which case is easier to prove? That he was murdered in the house or that he was murdered by Karen Read?
I have so many questions. I think it's easier to prove that he was murdered in the house.
Tell me why.
In my opinion. I mean, where's the dog? Where's the dog? I saw the photos of John Proctor's right arm that were taken at his autopsy. They have what clearly looks to me to be like animal scratches on them. All of a sudden, the family dog of 7 years, they had a German Shepherd in the house. The family dog is gone. They rehomed the dog. The dog is missing. The dog's DNA cannot be tested to see if those were, in fact, animal scratches. You know, there's a cocktail glass allegedly on the lawn. They never searched the inside of the house. Why did they never go inside the house to see if they had those type of glasses inside the house? Why was the basement flooring ripped up? The house was sold. Why did this police officer who owned the house and his wife never come out of their house to look at the scene when there is a dead police officer on their lawn? I have so many questions. And I think at the end of the day, the jury is going to have to decide the facts. And if we have so many questions from looking at these facts, I think a jury is going to have a lot of questions too.
So, did you hear all that? That right there bothered me. I'm like, okay, so you're explaining to me that there is a dead police officer, a fellow police officer, a comrade, that is laying in your lawn that has passed away, and you and your wife never step out at all? At all. I don't understand that either. And then I don't. Okay, let's just hear what Jennifer says to all this. Hold on, I gotta take a migraine pill. Okay, here we go.
Jennifer, which case is easier to prove?
Oh, without a doubt, the case that he was hit by KARENREAD. She had the motive. These are not dog scratches. That has been said by two medical examiners, separate medical examiners that examined him. Also, there were samples sent to a lab in California to test for non-human or canine DNA. Negative. So I find it so interesting that people want to look at a picture and all of a sudden they're medical examiners, they're doctors with PhDs, and they can say these are dog scratches. Second to the point there, the Brian Albert, they sold their house months and months after that. Also, they had a leak downstairs in the basement that resulted in quite a lot of damage, and that's why the flooring was replaced. As far as the dog, Chloe got into a fight with another dog in that neighborhood. And during that fight, one of the neighbors went to separate the two dogs and was scratched or bitten. And it was decided amongst the people that they would go ahead and rehome the dog.
She has an absolute excuse for every single thing. And I call it an excuse because it doesn't make sense. It doesn't to me. The timing doesn't work for me. So there's something weird with the timing. There is a man laying in the yard that not only do you know, but that you work with, and you're boy in blue, and you're not out there in a panic praying that he's okay. You're not concerned. You're not curious. That's weird. But you're going to hear the defense tell the judge that the one man in the house and the other man in the house that are comrades of John O'Keefe actually were in the basement allegedly, but claimed to be in the upstairs of the house. Okay, then you hear about the basement being ripped out, the floor, during the time that this would have occurred, where this man lost his life. This gets really interesting, so I hope you'll stay with me. Let's let her finish. Oh, and then the dog gets given away and the house gets sold. So let's get rid of everything evidential before trials. What? Okay, here we go.
As opposed to making an even larger deal out of it. So there are very logical explanations, but these are the types of innuendos that have been completely blown up.
Innuendos that have been completely blown up. Ugh. So I thought it was interesting. I wanted to look at these pictures myself, right? And I don't know anything about dog bites, but I do know if a car hits you, that it's going to leave different marks depending on where you hit. I don't know what would have caused these deep, deep gouges. I wouldn't even presume to know. But what I am curious about is if there is somebody that handles dogs on a regular basis, that might work for the police, that trains dogs and sees dog bites all the time and knows what a dog bite looks like. And could they help us? Well, Melanie Little didn't just leave it with Mrs. Coppanyapper there. She continued on her channel, and I followed her, and she went and got the exact guy that can prove her point more clearly. Now, there's no way for me to determine if this is a dog bite or not. I have no skill set for that. None. I don't even know if it looks like a car hitting. To me, it just looks like an animal. I would just say an animal tore him up. But then I could be wrong. So I wanted to hear what this expert has to say. Now, his name is Garrett Wing. All right? I want to say hello to Linda Burgott, Marjorie Holloway. Hey, Hey, Kim House and Gemini 65. Hello, Karen Guy Lovely. Here we go. Let's hear what she has to say.
Scenarios. How
And I want to throw a shout out there for Melanie Little. She is an attorney and she also has YouTube. And she's the one that brought on Garrett Wing. So thank you, Melanie. And here you go.
German Shepherd specifically would behave as a trained canine dog, and how one would behave if it was a household pet, and how one would behave if it was a failed canine dog. And I know that you have some video to show us. So let me know which one you want to handle first.
Sure. So I think the first.
I do want to make sure I'm clear about this. There is no discrepancy that there was a German Shepherd within the home that John O'Keefe was laying on the lawn of. So this is a German Shepherd in the home, and the defense is alleging that the wounds on that right arm look more like an untrained police dog, right? Untrained or poorly trained, or as they call washed over, because the dog isn't up to par, if you will, for actual police duty. And the reason is because it's more of a soft bite, and a tear is what this gentleman's going to explain. Whether that's true or not, I don't know. But I find that interesting that there is this dog in the house. It is a German Shepherd. And it has, now we know, bitten. So it is an more aggressive dog. It's not like, no, this dog would never bite. We just heard from, we'll just call her JC, that this dog was re-owned, right? Given away because of its aggressive nature. All right? So let's see what, and why would the dog attack him? Well, that's going to come up in a little bit later.
First thing that stands out to me, so I'm assuming, and I don't know too much about the case, I don't know too much about the dog. Chloe, I'm assuming this is a female dog?
I would imagine if her name's Chloe, but if anybody knows for sure.
Yeah, and the reason I bring that up is it's extremely rare to have a female police dog. It's very, I think in my entire career I've seen two. Extremely rare. Takes a very special dog, period. But we usually pick the males because of that testosterone. They can handle it a lot better. Because it's a tough job. And not to say the female dogs can't do it. It's just very, very rare. So it's possible that she was a washout. We do have a lot of police dog washouts. They typically are washed out for what we call bad nerves. Meaning they can't handle that stress. They can't handle the gunshots, the violence. We would do simulated type of, we actually do tremendous amount of testing. We can go deep on the testing of just what it takes for us to even select a potential candidate to get enrolled in a police canine program, which takes anywhere from 4 to 6 months. Once we take the dog, still 4 to 6 months of training all day, every day to get them qualified to even hit the street. So we like to do a very robust testing process before we even take the dog in. And I can dive into the details on what some of this testing might be, but one of the things would be just testing the nerves. Can the dog handle the stress of a simulated encounter with a bad guy?
It seems it's been confirmed through the animal control records that Chloe was actually a female German Shepherd.
Okay.
So does that change your opinion at all? Or let's move on from here. Let's see what videos you have and what you can show us about what a German Shepherd attack would look like.
Sure. So I came across this video just in my own research of what I do daily. We do a lot of reviews of dog bites and dog fights and things like that. So this is fairly recent. This is actually from my hometown where I grew up in South Florida, Cooper City, which is a small town outside of Fort Lauderdale.
So what he's about to show us, you guys, is an actual German Shepherd that attacks a mail carrier. And we're going to see that wound, and you're going to see how the attack of the dog is. Now, this is not a police dog. This is an untrained dog. And the reason that that's so important, what this guy is explaining, that a true police dog is trained to bite and go deep and like lock on, because that actually does far less damage and it secures the perpetrator. Whereas a washed over dog or an untrained dog, just a normal German Shepherd protecting its home, tends to do more of a shallow bite, and the wrenching of the arm, pulling it away, yanking it away, and the movement of the dog itself or somebody grabbing the dog by the collar can cause this shredding, this ripping lacerations of the arm. And we're going to get to witness what that actually looks like. So for those of you, we have a goat. I'm going to hold it pretty far away. I don't want to upset anybody, but if you have your boss listening or you have headphones on, this is a loud scream. It is not me. It is a little toy we have that is our mascot named Billy the Goat, but it is our trigger warning. So this is letting you know we're about to look at something very gross. Okay? And a little bit gory. All right. Here you go.
And so I'll share my screen here. And this is a delivery driver, fairly recent. I'd say this is 3 or 6 months old. She comes and delivers a package. I guess she left something, so she comes back. And you're going to see a German Shepherd that I am very confident has little to no training. This is not a police dog.
Okay.
And you will see, because what I want to kind of frame here is you don't need to be a trained police dog. You don't need to be a trained protection or, quote, attack dog to be a dog and bite someone. There are a lot of dogs out there biting people left and right with little to no training. And when we get into it further and we talk about the actual injuries, it actually plays into the dog that, if he was bit, that doesn't look like a police dog bite, in my opinion. And we'll talk about that. But let's go ahead and show you this video.
So he is saying to him, in his opinion, and he is a professional, but it is still his opine. He is opining, as they say, that this female dog, Chloe, if she did bite him and let this damage, if, she would not have to have any police training at all to bite like that. That is a German Shepherd thing. Well, a dog thing, but also German Shepherds, because they're very protective of the home.
And see what you all think about it. And it's a little gruesome. I'll warn you now.
Yeah, trigger warning.
Yeah.
Trigger warning for anybody who's sensitive to this.
I'll get to the part where this is her after the bite, and I want you to kind of pay attention to the type of injuries you're seeing. And the thing that I want to just continue to point out is the type of injury. A lot of people think of dog bites are puncture wounds. It's very rare that a dog bite is a puncture wound. They are often lacerations. Think of it as sticking a knife in and pulling, because naturally that's what dogs do. They bite their prey and they pull. And or if you were to get bit by a dog, the very first thing you'll try to do is pull away, and it creates those types of injuries. So let's go ahead and go into the video here. This is after the woman is bit. She's in her car and she's a little shooken up, and you can see right here, and we'll play it in a minute, but this is not a puncture wound. This is a laceration from a dog bite.
I do not with the help me!
Terrified
And then
dog attack.
Watch how quickly this goes down. Again, very confident that this is not a protection dog. This is a German Shepherd doing what German Shepherds were bred to do for hundreds of years. Protect their home.
That attack captured by her own dash camera.
All I can say was, help me, help me. I thought I was going to die.
Deanna Riveros needed more than 30 stitches.
I'm going to go back to that. See the laceration?
Yeah.
Let's take a look at that, right? Now, let's see. Let me see if I can make this small enough, and we'll get both on the screen at once, perhaps. Perhaps. We'll see. How we doing? You see that? Do you see where there's some similarity? Give me a 1 if you feel that these do. I mean, we're not doctors. We don't know. But I'm curious where everybody's kind of opinion falls. Give me a 1 if you feel that these look similar. that this, in your opinion, could match, the one right here, talking about dogs, mine are out barking. This one over here is a absolute dog bite. This is dog bite. Okay? You can see where it's shredded the skin. As she pulled away and the owner's pulling the dog up, the teeth go in and pull, right? And there's one here, and there's one here, and one here, and you can see a puncture wound here. And then over here, this is John O'Keefe's right arm. We have this laceration and this one and these and all this. And I'm just curious. Give me a 2 if you feel that these look completely different and you just can't see that this is a dog bite at all. And give me a 3 if you're just not sure. So a lot of you are thinking like Cat K, that it's very similar. Linda is a 1. Yeah. Okay. All right. Let's go ahead and continue.
That's not a puncture wound, but we're all pretty clear this is a dog bite. Yep. She got bit. The weight of the dog alone biting and trying to pull its prey down to the floor, and her potentially pulling away is what causes this. Especially too, and we see this a lot in police canine work, when the dogs bite, we are actually taught to provide what's called back tension, and it makes the dog bite harder. And or when you see police canine handlers who aren't as good as they should be, when they go to remove a dog off of a bite, they're often doing what's called a choke off. And you can call it a choke off. It's more of like a rip off. And they will actually grab the collar of the dog, especially these really high just high drive dogs in general, which we train all day, every day. And we're basically telling them, never let go. Hold on. No matter what happens, don't let go. And oftentimes you'll see police dogs. This is a story for another day, but they often do not let go on the 1st, 2nd, 3rd, 4th, 5th command, because they're like, make me. And so you're forced to pull the dog off, and it creates really, really bad, nasty lacerations. So we'll play this just a little further, but you can see how quickly this, my opinion, is completely untrained German Shepherd just goes right into action.
I just want to point out, wait, just stop for 1 second.
To walk
Sure.
after what
I want to point out that you said lacerations, and that the medical examiner in her report calls those injuries abrasions. Abrasions.
Not an abrasion. No. Nothing close to that's not like a curb rash or street rash, or you fall off your bike.
Scrape.
We've all been there, a scraped knee. There's no abrasion there. There's just straight up lacerations and potentially some puncture wounds.
So what are you guys' thoughts? I see there are a couple 3s. Not sure yet, right? And there's a lot of trial to go over. It isn't just based on this little summary here. I do want to look at this. He goes a little bit more into detail. And I thought this was important. So we're going to go ahead and give him the floor a little bit. And then we're going to jump into the actual court hearing and hear prosecution and the defense and what the other big issues are.
All right.
I actually sent this photo to 2 other police canine handlers and who are also trainers who themselves have seen countless bites. Probably between us, we've seen, hundreds each. And I didn't say anything. I said, what are your thoughts on this? And they said, there was zero question that this is a dog bite. Zero question to them. Their thought, though, was that this was a police dog that probably should have been washed out. This is not what we want to see on a police dog bite. We don't want to see constant re-engagements, which is what this looks like. But this is what I would expect from like that German Shepherd we saw bite that lady, the delivery driver, right? Just naturally going in, doing as much damage as possible, not understanding the mechanics of biting deep and holding. These, in my opinion, are bites utilizing the front of the mouth. Furthermore, I had seen video, and I could be wrong, but when Mr. O'Keefe was last seen on that surveillance camera in the bar, it appears like he's wearing a long sleeve shirt, almost like a sweater maybe.
Yeah, somebody was asking that exact question. So let me pull up that exact question, but keep going.
And this is exactly indicative of a dog, and we see this even with trained police dogs, when someone's wearing baggy clothing or long sleeves or jeans or a jacket, you're gonna get these more shallow bites. The dog's constantly trying to get a grip on the prey. And of course, the prey item is moving away, and you're gonna get these, this is what's considered shallow bite marks. This is the dog trying to get a grip, but the only thing that's sinking in are those front teeth. And the biggest thing that kind of stood out to me, I don't know if you can see my cursor or not, but this bite right here, so I'm even calling it a bite. I'm trying to stay objective here, but these look like, and you see this a lot with shallow bites. What it looks like is this is maybe the left canine, maybe the bottom right canine, or the canine here, but these.
Is there a way for you to enlarge that photo on your screen? Yeah, there we go. It's a V shape.
Looks like the front teeth. Think of the dog's, let's say potentially the teeth were here, the bottom teeth were here. These little ones here are the little, and I'm not a veterinary dentist by any means. These are the small little baby teeth.
So you get what he's saying. To him and others, that appeared to be a dog bite. So that is a big issue for many people, is that the injuries are on this right arm. But he also has multiple injuries on his skull, including the back of the skull. You know, how tall is her car? I don't know. It's an SUV. But let's go ahead and let's talk about what other big, like the major points of the trial is really going on here. Well, there are behind the scenes some texts that, and meetings, if you want to call it that, between KARENREAD and someone in the house where they were somehow alone and a kiss happened. So was this guy hung up on Karen and decided to, got mad and killed John O'Keefe over jealousy? I don't know. That's something that the defense is kind of hinting at as well. But let's dig into this a little bit and hear what happened, or what was the most important to me out of what I've heard so far about the court trial itself. We'll switch screens and we'll get over here.
Lily.
Let's see what this one is. Oh, this is if the feds who investigated this case, I'm going to let you hear what they have to say, what the prosecution and defense has to say. Are they going to allow anybody in the jury to even know that there was a federal investigation? Or will that be suppressed? Because of most, if not all, of the evidence that this was allegedly what the defense is claiming, that this is all framing Karen, and that's actually people beating John O'Keefe up and the dog attacking him. And if the defense is claiming, well, this is all the work of the feds, what happens if they can't even talk about anything about the feds? How are they going to justify to the jury where this information came from? I don't know. Hey, Interior Family Studios and Jenny Troglin. Thank you, my beautiful people, for modding. I love you guys. Yeah, this gets crazy. I'm going to stay on this case till it's over. It's something I can't let go of, but I always invite my family, my 1111 family, to go through it with me. I have no idea at this point. I'm constantly just a sponge taking in info. I want to listen to the trial. I want to hear your opinions. You guys tell me what you think, and I'll show you what we got. So here you go. We've got quite a lot to go over, and so I'm going to let this play in long streams without interruption. This is, right now, this part is for educational purposes, right? Here we go.
Yes. So, Your Honor, this motion eliminates in reference to prohibiting reference to any federal investigations conducted by the U.S. Attorney's Office or the Federal Bureau of Investigations. So, to this point, the U.S. Attorney's Office has publicly confirmed that at no time has the U.S. Attorney's Office named any person or entity as a target. So, any sort of reference to, and essentially what they've stated throughout the course of, and I know the court has had a chance to review those materials, but what they state is essentially their investigation into some unnamed criminal activity or some unnamed crime or there's nothing specific to any specific person or entity that is contained within those materials. So what the Commonwealth is submitting is that any reference to the fact that those things occurred is therefore unfair, essentially biases against one side or the other based on that, and it really has no relevancy. As far as making reference to, if counsel at some point, either side, wants to make reference to testimony or statements, reports, things of that nature that were provided in the course of that discovery pursuant to the TUI, obviously that's perfectly permissible, but it also can be done without making reference to where that item came from. As far as you testified previously in relation to some investigation on such and such a date.
So basically, the Commonwealth, which would be like the state, right, is basically saying you don't have to reveal that it was feds that you talked to. So in other words, if you were asked, when did you make that statement? And they want it so that the feds' names are left out of it, as if an investigation did not occur by the feds. Just it was some agency, right? But why would you want the feds left out? Well, the feds are investigating a corruption possibility. They are double checking that the police officers, as well as anybody in the case, was behaving properly. Unfortunately, the Commonwealth, right, in this case is acting as a state, may be biased. We have to consider, are they biased as a Commonwealth? Because basically the state is going to protect its own counties, right? Feds are supposed to be unbiased, so they're considered third party in a sense. And so if this is an unbiased investigation, why would the Commonwealth not want the feds' names brought up in a national case like this? I don't understand that. Is there some reason why you don't want that weight behind what the name, the feds, stands for and what the feds came out with? Like you don't want the weight of how people in the jury would be like, oh, the feds said that? Oh my gosh. Is there something like that you need suppressed in a way? I don't know. It's off. Why? Just why?
You spoke to a law enforcement agent on such and such a date and you said this. So if it's needed for those kinds of reasons, as far as impeachment and whatever, that's obviously perfectly permissible, but any reference to that in front of the jury, Your Honor, is something that the Commonwealth would submit is simply impermissible and irrelevant to the facts as they pertain to this case. So for those reasons, the Commonwealth would ask that this motion be allowed.
Is there an objection to this?
There is.
Now, before the defense gets talking, because I'm a absolutely stay out of this part. So this is going to be about a 5-minute run here that you're going to hear uninterrupted. I just want to say that in this scenario, I just sounded like Rascal a Rabbit. I stuttered a little bit. In this scenario, in this particular argument, okay, not in the case itself overall, in this particular argument, I am concerned that if the jury doesn't know where the information comes from, that it would discredit it as not being factual. That's what I would have a concern for. I mean, that's just my thoughts. What are you guys' thoughts? Don Cullen, hello, lovely. Linda Annie, I haven't followed this case. I'm hearing it from the best. Aw, thank you, Linda Annie. Kiwi from New Zealand, hello, new sub, loving your channel. Well, welcome, lovely. Welcome, Kiwi. All right, you guys. Hey, Jeff, welcome back, love. Let's continue. Just so you know, before we start this 5 minutes and 21 second long spill, it's worth your time because I learned so much from this little message that the defense gives out here. Like, I learned a little bit about how it should be working in the Idaho 4 case and so forth. There's a lot of information being given in this hearing. And I welcome you to really be a sponge here because as we dig in, I'm putting my feet firmly in the Karen Read case to figure out what is going on. What in the world is really going on here? And so I hope you take that journey with me. But I also hope that hearing all this today, because it's a lot, we're going to be here long time. Love you a long time, right? We're going to be here quite a while to be able to hear all this. So I gotta be quiet. Here you go. 5 minutes, 21 seconds. Take it away.
The Commonwealth's position can be basically summed up in their moving papers with the following sentence that they drafted. The proceeding would be unfairly prejudiced if the defendant is permitted to rely on the mere appearance or existence of a federal investigation, especially where the investigation was shaped and influenced by the defense. First of all, the defense does not and did not shape or influence any federal investigation. The federal government is more than capable, Your Honor, and I think the Commonwealth knows this, of making its own decisions and about its own investigations. Second, and just as importantly, the Commonwealth cites no authority whatsoever that stands for the proposition that the mere mention of a federal investigation prejudices state court proceedings in any way, shape, form, or fashion, and that's because there is no authority. That authority does not exist. But most importantly, and this is critical, it is going to be critical to give the trier of fact, this jury, the proper context in which every one of the statements or every bit of the evidence is presented and how it came to light. It's essential for the jury. How
are you going to do that? How do you propose it? Is somebody from the U.S. Attorney's Office on your witness list to come in and talk about it?
There are federal agents. No. We don't anticipate presenting the fact that there's a federal investigation.
Isn't that what this does if you mention it?
No. What this does.
Explain to me why that's not so.
That's what I'm doing.
Not yet, you haven't. So please explain that.
As the court knows, it's essential that the jury is given the context in which every single statement, whatever the statement might be, is brought to light.
Does that mean, do we say in the prior trial that resulted in a mistrial, you said this?
No, but you would say when you were speaking with Officer Smith or Officer Jones from the Canton Police Department at the Canton Police Station in this particular context, did you say this? When you were questioned by the Commonwealth's attorney in this proceeding, did you say this? When you were questioned by the United States attorney in this hearing, did you say that? That's what we do. Otherwise, it's perpetrating a fraud on the jury. The information that's gleaned during the federal investigation was revealed, Your Honor, importantly, by a neutral third party. A neutral body that's not connected in any way to this case. The Commonwealth has a stake in this case, very obviously. The defense certainly has a stake in this case, but the federal authorities have no stake in the case of the Commonwealth versus Karen Read. Thus, the evidence procured by that neutral agency, which is independent of the case, is subject to a different and completely different level of scrutiny, a completely different level of assessment by the jurors. That is an important fact. There is no other way to truthfully and honestly present this evidence to the jury. Think about some of the questions that the court just posed. What were the circumstances in which you changed your testimony, sir? He's going to say, well, I changed my testimony, potentially, when I was called before a federal grand jury and I was asked questions under penalty of perjury. Why did you finally admit certain things when you were confronted with additional evidence, ma'am? And where did that evidence come from? Well, I was called before a grand jury and I was asked, or I was I was interviewed by a federal agent and I was asked or confronted with additional information, text messages, phone calls, etc. Or the third example, where did that additional evidence come from, officer? Text messages, phone calls, private communications. Oh, it came from a hearing in which I was questioned by a United States attorney under penalty of perjury in front of a grand jury. The jury's entitled to those answers in that context. If we were to do what Mr. Lally suggests, if we were to take that invitation, oh, well, you were asked by a prosecutor at a former hearing XYZ. That would leave the jurors with the imprimatur of the idea that the Commonwealth elicited those questions, that the Commonwealth did their job, when we know, in fact, it didn't. The answers to those questions directly go to Ms. Reed's Bowden defense. Bowden talks about the inadequacy of an investigation, obviously, and Mr. Yannetti can talk more about that in just a second. We have information that a different agency was able to uncover information that the state investigation ignored. That's important, and it's important for the jurors to be able to weigh and balance that information and how the information came to light. If the truth is actually hidden from the jury, which is what the Commonwealth is asking the court to do, that the evidence was produced was the product of a third party, the truth being that the evidence was the product of a third party inquiry, unconnected to the state court case, then that jury is left with a false impression, false information, and it'll be unable to properly assess the true facts, which is what we're trying to get to, the true facts. Why is the Commonwealth so intent on hiding the truth from this jury?
All right, I was busy texting. I think I'm going to be on Tommy Jude's channel on May 4th at 7 p.m. Don't quote me. I didn't go back and double check, but I seem to remember something like that. All right, you guys. So as you can see, that is something that's on the table, and the judge made the decision. I haven't followed up on it. It was today, so I will follow up on that later and get with you probably tomorrow and let you know, are we going to be able to talk about the fact that there's a federal investigation in the case and that that's where some of these reports are coming from, and that witnesses were interviewed by feds and what was said to the feds, right? And what were some of the findings by the experts of the feds? So there's a lot there to consider, and that's another one. Not only is the autopsy in question as to, is this really damage that was done to John O'Keefe by a vehicle, or was this a dog bite and possibly fist biting, because allegedly his hands are all tore up around the knuckles. So that's another thing, but I haven't seen the photographs on that yet. So those are some of the high points of the trial that I personally picked up. Is it going to be talked about that the feds actually did an investigation? Is that going to be suppressed or allowed? They're going to be talking about the autopsy results, and there's different experts that totally disagree. Some are opining that it looks like a vehicle hit this man and that's how he died. However, what's really interesting is that there's cause of death, and then there's manner of death, right? And so one of those sections is still on the death certificate as undetermined. And I guess that is being suppressed, from the best of my knowledge, in trial from the jury. I'm like, wow, interesting. So the big question is, what is the defense coming to the board with? Because we've heard that the prosecution wants to come in and they're alleging that Miss KARENREAD basically got sloshed, and rather than dropping off John O'Keefe, she actually backed over him. It began to snow, and then when she returned the next morning, she was, there it is. She hit him. She was drunk and she hit him. Now, I believe it's with intent they're claiming. Like she was so angry she did it, to the best of my understanding. Originally, I believe it was going to be more like a manslaughter. Like she didn't know she did it, but she's negligent because she was drinking. And now I think they've upped the ante quite a bit. And now it's like you intentionally were mad, or you were mad and you intentionally ran over him, backed over him, right? All right. But now we're going to hear, are they going to be allowed to bring in the third party concept? And why would they suggest, as the defense, that rather than defend Karen in a means of saying, well, I didn't do it, they are choosing to say not only did Karen Read not do it, but they believe third party people did it. So I wanted to kind of go over that so that you understand that before we get into the trial on Monday. And here we go.
Thank you.
And though they're argued together, I do want you to also start with the third-party culprit alone, not third-party culprit as it goes to Bowden, but third-party culprit alone.
So I just want to make mention on the sound quality. That is actually coming from the courtroom static. It is not nothing to do with me. It's nothing to do with Court TV. You're also going to hear our judge, who is unfortunately a heavy breather on the mic. Okay? Just saying. That's not me breathing on the mic. That's nobody that's recording it. That is the judge breathing heavy on the mic. She's a heavy breather. Just saying.
Because of all those factors that I told you, as you well know, the case law is clear, that I have to consider. And if I had to do it now, and you know I can do a pretrial, right? You know that today I can just exclude it. I'm not inclined to do that, but I need to be able to make those decisions, to weigh those factors, because right now I have zero information on
Right,
this.
I understand that, Your Honor, and that was my plan going into today anyway. So the initial question is, why is there a third-party culprit defense? Why is it relevant? And we start, Your Honor, with the fact that our forensic medical examiner, Frank Sheridan, a pathologist, forensic pathologist who has performed himself thousands and thousands of autopsies, has already submitted a sworn affidavit to this court that John O'Keefe's injuries are consistent with having been in a fight and are not consistent with having been hit by a car. Since he submitted that affidavit, the federal authorities have provided us with their reports, whereby FBI experts also corroborate that John O'Keefe's injuries are not consistent with having been hit by a car. They employed experts in biomechanics and kinematics who have reviewed the evidence in this case, and they've confirmed that the physical evidence essentially shows and doesn't show what Dr. Sheridan has opined. So therefore, if John O'Keefe was not hit by a car, that means that Karen Read did not kill him. And we know that John O'Keefe did not die of natural causes. This was not a heart attack or a stroke. John O'Keefe was injured. He was mortally injured. If he was not hit by a car, as both our expert and FBI confirmed, then he was attacked. And if he was not hit by a car, then there is a third-party culprit or culprits. So by asking this court to prohibit the defense from introducing evidence that others had the motive, opportunity, and the means to attack John O'Keefe, the Commonwealth is essentially asking this court to prohibit Karen Read from being able to defend herself.
So I don't think they're asking that you be prohibited from doing that. They're asking first to have you tell them what that is.
Right. Well, this is, Your Honor, I'm getting to that in terms of
Right, so go ahead. You have your remarks.
That we're either required to give them or not. It is not our job to solve this case for the prosecution. It's our contention. They had the opportunity to do that, but they failed. It is not our job to name a specific third-party culprit. We do not have to prove that Brian Albert or Colin Albert or Brian Higgins or some combination of them intended to kill John O'Keefe. We don't have to prove that any of them attacked John O'Keefe such that he eventually died. They have to prove beyond a reasonable doubt that they didn't. But the fact of the matter is there is evidence that all three of them had a motive, had the opportunity and the means to attack John O'Keefe. Now, the Commonwealth cites Commonwealth versus Conkey in their motion, and as this...
Before he gets a lawyer on us and gives us another case to listen to, what he's basically saying is that the prosecution wants the names and what you said these people did allegedly and who took the final blow and a step-by-step like what they're alleging happened that took the life of John O'Keefe by the third party. What I'm understanding, to the best of my understanding with no legal training, is that the defense is saying, listen, that's not our job. That's your job. And the reason is because there is allegedly enough circumstantial evidence in the autopsy reports that the defense is alleging is saying that John O'Keefe was not struck by a car in what the defense experts and the Fed investigation, and this is all what the defense is alleging. Keep in mind, there's no proof on the table. This is talk right now. We're not in trial yet. This is just basically the defense stating what they believe. And they're saying, we don't have to give the name and all that. Okay, we don't have to give who all did this. We're saying that the injuries don't match a car accident, that the injuries match being beat up. If the injuries don't match a car accident, then KARENREAD would not be guilty. And that's their job, to defend KARENREAD. However, go ahead and listen, because this right here, it almost made me want to go to law school, because this dude can tell you a story that damn near has you on your feet in the end. I wish we had this kind of lawyer and this kind of a defense attorney in other cases, and I'll just say it like that. Listen to this.
The court started the discussion on this issue when you first took the bench. Conkey makes clear that a defendant has a constitutional right to argue that somebody else may have committed the crime. And certainly, no, the acts of that person can't be too attenuated in time or method of operation, as Mr. Lally mentions. But in terms of being the right time period, Your Honor, you can't get any closer than their presence at the scene at the very time that John O'Keefe was killed.
And yes, my lovely Susan Rusco, these are names of, I believe you had asked, these are names of fellow officers that are allegedly, at least the defense is claiming, are at the home at the time of Officer Keefe, his demise. However, the prosecution differs. They do allege, the prosecution is alleging that one of the people that the defense is claiming was there had already left prior to O'Keefe and KARENREAD arriving on the property. So there is a discrepancy. I don't know who's right. We'll have to watch a trial. But prosecution is saying one of the people that the defense is naming and saying was there wasn't. They had been, but the prosecution alleges that that individual, which we'll get more familiar with the names and so forth, had actually left the property prior to KARENREAD and John O'Keefe getting there. But let's continue with the defense.
In terms of the method of operation, given that we have evidence that he was not hit by a car and that he was attacked, all three of these men, either alone or in combination, possess the ability to attack him with or without a weapon. I mean, that's a very low standard here. The Commonwealth acknowledges that. It's a low standard of simple relevance. And the evidence here establishes relevance. Now, I would note, Your Honor, The Commonwealth cites Commonwealth versus Finney. I don't know if they realize this, but that was my case. I represented Roland Douglas Finney before the Supreme Judicial Court, and I represented him at his motion for new trial and at his retrial. And that case, the Finney case, provides strong support for the introduction of third-party culprit evidence here, irrespective of a Bowdoin defense. In fact, the reason that Mr. Finney's conviction was overturned was that his trial counsel failed to pursue a third-party culprit defense.
So, what he's basically saying is there was another court case, and he actually worked for that case, the guy talking, which is the defensive attorney, and he worked that case, and what it came out to be, and the reason that case, as far as I'm understanding, was overturned was because they failed to acknowledge or follow up on the possible third-party involvement. So he's kind of like boasting about the fact that, listen, the last time nobody listened to the fact that I was trying to interject that the third party was involved in the crime on that trial, on the Finney trial. And that ended up a big waste of time. It ended up getting overturned later. And again, he's basically saying to this judge, are we going to repeat that same thing and repeat that same mistake? Because he's very familiar with not being heard about the third party. And in this case, the third party happens to be the boys in blue, right? The comrades of Officer John O'Keefe, who were the ones throwing the after-bar party. All right? Kim House believes it sounds like more corrupt officers. Okay. Susan Roscoe says anything mentioned about the possibility of Karen being involved with one of those officers, just a thought. Well, yes, in a way. They have brought up that Karen has allegedly planted a kiss on a federal officer while he was on duty in John O'Keefe's house. There is an alleged claim that KARENREAD was in I believe a room, I'm not sure where, but with one of these officers prior to the murder or homicide of John O'Keefe, and that she had a little, nothing really happened but a kiss on a kiss, like a peck, between her and this person. But that person, the defense is claiming, actually texts Karen prior to the murder, just hours before, or within the hour, I'm not sure, very near the time of the death of John O'Keefe, and was like, well, but you're gonna hear more. This is a lengthy, but this is our digging in and understanding the case. So you're gonna hear a lot.
And Your Honor, the third-party culprit defense in Finney was weaker, far weaker than the third-party culprit defense we have here. The evidence of motive in that case was that the third-party culprit made derogatory statements about the victim after she was murdered. No witness in that case put the two of them together. No witness in that case put the third-party culprit at the scene of the murder where the victim was murdered. There was some consciousness of guilt evidence similar to what we have in this case. But in Finney, the SJC ruled that not only was that enough for a defense attorney to present a third-party culprit defense, but he was ineffective for not doing so. And as the court has also touched upon,
the poor judge is clearing her throat. You've heard her sigh, because he's saying that the counsel was considered literally later ineffective. In other words, they didn't do their damn job because they refused to even think of third party in that previous case. And so, which is the Finney or whatever it's called. And so he is putting it out there to this judge. You don't want to look like that, right? You don't want to go through that as a judge. You don't want to be, right? So he's really laying it on the line, kind of giving it to the judge, basically saying, you know, there's a lot of eyes on this, and other cases have proven that it's in the best interest of the court, in his opinion, in the defense opinion, to allow the third party reflection to see if a third party actually, investigate the whole thing. And that way it's all on the table. Now, keep in mind, I am not a lawyer. I am just a mom. So this is all my interpretation. Cat Case says, I really need to read up on this case. I don't know much about it at all. Well, you're kind of learning the basics here today. It's like our crash course into the KARENREAD case. And this is basically saying that before we start trial, we need to be able, from the defense's perspective, to be able to talk about the federal investigation that happened, because that's where we got a lot of our findings that we're going to be bringing up in trial. And we want to be able to use the weight of a federal investigator, right? We want to be able to say this is from the feds, so that it has weight in that it is a true investigation. We also are looking at, like I said, the condition of the deceased. Do their injuries match what the experts would claim, which, again, you got to remember, prosecution does have reports that suggest that it would be basically a car accident, I believe. To the best of my knowledge, that's prosecution saying their experts are agreeing with them. But then you listen to the defense and they're like, no. We've even got feds that are saying no. So I guess it's going to be an interesting trial. Scott Perkins, you said, I don't know a lot about this case, but the dog bites and Google search, for some reason, those two bother me. Unless it's false, then no way. Right. I'm very interested in this case. Very interested in this case. Jennifer Swain, thank you, lovely, again for that snooper chat. That was a $50 snooper chat. Blows my mind every time. You are so incredibly generous, and I appreciate your support of our channel, of me, of our 1111 family, and those that we try to help bring awareness about. And I'm always open to understand all these different cases, to understand if there really is corruption or not, and what can we learn from the trial itself, so that we don't repeat mistakes, but we learn from them, right? Jennifer Swain says, I believe Karen says she didn't go in the house and that he took too long and she decided to leave. Okay, I had not heard that. I had not heard that yet. There's a lot I don't know, you guys. I am not an expert in this case. I am learning with you. Gemini65 says, wait, I lost that. It just jumped like crazy. Something about selling the house. Well, oh, you took it away. That's why I couldn't find it. All right, let's get back into this, lovelies.
The SJC found that on the basis of that third-party culprit evidence, which is weaker than what we have here, there were substantial connecting links between that third-party culprit that justified the admission of hearsay in that case. And I want to make it clear, we're not looking to introduce any hearsay statements, so we don't need substantial connecting links here. Now, Your Honor, I could go through with the court the specific evidence we have with regard to motive, opportunity, and means with regard to the three Commonwealth witnesses that I've named.
All right, so the judge, and I know somebody's going to jump me and be like, God, stop commenting. You guys, go watch this on Court TV all the way without one word from Mama D. I recorded this so that I can comment, and that's what I do here. So bear with me. What he's about to talk about is he's saying I could go over, even though it's not my job, I could go over and present to the judge and the court at this time during the hearing who specifically, right, the three individuals that we feel are suspicious, that they may fit the, accessibility to the victim, capabilities, motive, right? That would tie them to John O'Keefe himself. And the judge says, go for it. So this is about to get really long. Now, what I want you to keep in mind, the trial has not started. This is not testimony. Truly. Nobody swore in a Bible. He could be stretching the truth. He's going to have to back it up with evidence when the trial starts if he wants us to believe every word coming out of the defense's mouth. That being said, I feel exactly the same way about the prosecution. But at least in this scenario, I believe, from what I understand, that up to this moment, nobody really understood like the full narrative that the defense is proposing may have taken place until this moment. So I was like, all right, this is a big nutshell. It's 24 minutes, but it ends in me understanding a lot more. Forgive me. But it is also the prosecution coming back, right? And counter statements are being offered as well. And it's going to give us a little bit of understanding of what the defense is portraying that happened. Okay? Again, remember, this at this point is a story being told that the defense is saying could have happened.
So go ahead.
Happy to do it. Starting with Brian Higgins. He was present at 34 Fairview Road on January 28th to 29th. He was close friends with the homeowner, Brian Albert. He had a prior romantic interest in KARENREAD. He did not expect Karen and John O'Keefe to be at the Waterfall, that bar, on January 28th. KARENREAD did not greet Higgins, despite the fact that they had previously exchanged flirtatious texts and that she had been at his apartment one evening, although there was nothing that took place between them any more than a peck of a kiss. At the Waterfall, Higgins does not engage with John O'Keefe. He does not say goodbye to John O'Keefe and Karen when he leaves, but before he leaves, he texts Karen, and that text was something to the effect of, well, with a lot of M's. We know that there was a preservation order from this court, your predecessor, Judge Krupp, to preserve his cell phone, and that Trooper Proctor gave him an edict, an order to serve on Brian Higgins, and he left it at the front desk of the Canton Police Station for him, and that Higgins, we learned through the federal investigation, Higgins became angry, demanded that Proctor come back, and he essentially upbraided him and read him the Riot Act, which shows a little bit about Higgins' personality. At the end of the night, everyone discussed going back to 34 Fairview, and when he gets back to 34 Fairview, he texts not Karen, he texts John O'Keefe at 12:20 a.m. He testified before the federal grand jury that he had no knowledge that they had been invited to 34 Fairview, but that is contradicted by this text message. And the inference is that he was coaxing John to come to that house.
Okay, so the defense is alleging that this, I can't remember the dude's name, y'all. I'm not that good at the case yet. But the officer, Adams, I believe that's who he's talking about, had claimed and actually testified, all right, to the best of my knowledge, that he had no knowledge that John O'Keefe was even coming to the party or invited in the party. Yet, later after that, the defense is alleging that it was proven on that man's phone that he had indeed even texted O'Keefe himself directly. So that's where we're at on that. It's true. Elise Kuhn says, I always have to giggle when you say I'm going to play this all the way through, and then we talk. And then I count and giggle again. You're very right. You're very, very right. Susan Rusko says, if some area cops were involved, I'd move, but I'd keep the dog. Right? Mm-hmm. Okay, here we go, lovelies.
And, you know, we're not saying this gives him a motive to kill John, but we don't have to show that. Any motive to feel hostility or animosity towards John O'Keefe goes to his motive. And, Your Honor, when Brian Higgins and Brian Albert are in that house, they're the only two people who are unaccounted for when the rest of the group was in the kitchen.
All right, I'm going to rewind it just a little bit. I know. Y'all are like, what? Because this is important. We're going to go back to, right? Oh, gosh. All right, that's the best we can get. So, the two Bryans, Brian Adams and the other guy, the two Bryans are the only two, they're officers of the law, fellow officers to John O'Keefe. They're the only two, according to the defense here, what they're claiming. The defense is claiming these two are unaccounted for at the exact time that John O'Keefe would have allegedly went through this horrific event. Now, listen close. They're interviewed or they testify. I can't tell which. But they make different statements as to where these... So they're supposed to be together. It's Brian and Brian, right? But they testify separately. And naturally, one testifies they are upstairs. The other one says, I've never been upstairs in that house in my life. Right? But he refers to upstairs. So it's all going to boil down that they would have to be then, because you would have to be in the basement to come upstairs. It's a third level, 2-level house with a basement. So if you've never been in the upstairs of the house, but you're reporting that you're coming upstairs, it only leaves the basement to be coming up the stairs from, is his point. So he's saying they're lying about where they were. Right? Now keep in mind, the floor in the basement gets all redone. Even Jennifer Coffin-Yapper tells you about that, of this house, before it's sold. And before they rehome the dog. All right? And then, as you get into this, you start wondering, why are people destroying their phones, pulling out the SD card and destroying it? According to the defense, that all takes place too. A lot of red flags here. A lot of red flags. Scott Perkins says, a lot of funny business in this case early. No investigation of the house. It's too much doubt, in my opinion. Louise Jeffries says she didn't confess. She asked. It's in the statements from the witness, Lion Lily. Okay. Well, I was just kind of doing a survey, if you will, like the Idaho 4 people, where I'm like, have you heard or read? All right. Doesn't mean, like I said, I am new to this case. I've been binging it for like a few days because my dog got neutered and I've spent a lot of quality time with him. And so I'm watching a lot on the KARENREAD case, and I wanted to bring you like the crash course so that if you're not familiar with it and you want to tag along with me and learn as we go, Monday, this is when it's scheduled to start, the whole trial on KARENREAD. And this will give you like the nuts and bolts, the bare essentials to be able to jump in with me. Jennifer Swain says this is a brotherhood that stands together at any cost. And the cost happens to be Karen, in my opinion. Susan Rusco, oh, fresh nut, Jennifer Coppin. FBI looking for her 15 minutes of fame, in my opinion, says Susan. Yeah, she is something else. Louise Jeffries says the United States Attorney Office have said that this should not go to trial in good conscience. They have more evidence than anybody, is what I've heard. I always have put is what I heard or my opinion to protect us that we're not making legal statements. Okay, here we go. Oh, Marjorie Holloway. You say first time? My first time too? Well, lovely. Here we go.
Any motive to feel hostility or animosity towards John O'Keefe goes to his motive. And Your Honor, when Brian Higgins and Brian Albert are in that house, They're the only two people who were unaccounted for when the rest of the group was in the kitchen. And they claimed that they were looking at photographs together. And we have evidence that they were in the basement. We believe that Brian Albert made a mistake before the state grand jury by testifying they went upstairs to look at photos. Brian Higgins says unequivocally that the only place the two went was into the living room to look at photos, and military ribbons, whatever they were looking at. Brian Higgins did not know that Brian Albert had said they went upstairs. And he also testified he had never been upstairs at Brian Albert's house in his life. That means that if Brian Albert said they went upstairs, they're coming up from the basement. And before leaving 34 Fairview, Brian Higgins testified he was parked right in front of the mailbox. He would have had to have walked by where John O'Keefe's body was. His headlights, when he got in his vehicle, would have been illuminating where John O'Keefe's body would have been in the yard if it were actually there. So how does he not see it? He then goes back to the Canton Police Station at 1:30 in the morning after leaving 34 Fairview. He claimed to do some administrative work, but then he admitted to the federal grand jury that he was there to move his car because of the upcoming snowstorm. This suggests that he was fabricating a reason for going back to Canton Police to establish an alibi for himself. He was asked several times at the federal grand jury if he had any conversations with anyone before he went to bed. And when was he notified that John O'Keefe was dead? In the morning, he said. He testified under the pains and penalties of perjury that he had absolutely no contact with any person that night for any reason whatsoever. But he apparently was surprised that the federal authorities had subpoenaed his phone records, and he had to admit, and he did admit under oath, he made that 2:22 a.m. phone call around the same about 5 minutes before Jennifer McCabe is Googling how long to die in the cold, about 8 minutes before Brian Loughran, the plow driver, first drives by the house and sees no body at all. And the next morning, Brian Higgins, the first person he spoke to was Brian Albert.
I'm going to stop you for a minute. I think we need a break, Madam Court Reporter. Do you need a break? Can you go? How much longer do you think you have with this, Mr. Yannetti? How many more pages, or how long you think?
Yeah, I've got about, in terms of my recitation of the facts, I've done about a page and a half, and I've got 3 left.
Madam Court Reporter, would you like to take a little break? It's hot in here, and you've been going nonstop. Okay, let's take a 10-minute break.
Saturday, he returns to the Canton Police Department where he speaks with all of the first responding officers who had anything to do with this case. So this is a quote-unquote witness accessing and communicating with all the first responding officers, we would argue monitoring what they're doing in regard to the investigation. According to Brian Higgins, he admitted that Chief Berkowitz is one of his best friends, and that's why he had access to all these people. We have a law enforcement witness who will testify.
I am not pausing it.
With KARENREAD.
When you see the red screen, you guys, they are blocking part of the live transmission of the hearing because there is information we are not to hear at this time. So keep in mind, I am not blocking anything. All right, lovelies? Scott Perkins says, anyway, back to the case. All right, all right.
Long time.
So is this a name that's been in the materials? Is this a name known to the Commonwealth, or
yes.
Is this somebody new? Okay.
We've now received video surveillance from the Canton Police Department that shows that there is an interior camera in the Sallyport garage where the car was housed. But during the exact time that third-party officer indicates that Berkowitz and Higgins were in the Sallyport together, the video mysteriously cuts out for 42 minutes between.
Okay. So I'm not exactly sure when this video was taken, but the prosecution alleges that the reason that this video just completely stops working for approximately 42 minutes is that it is a motion sensor camera, and therefore it has no motion to make it go off, right? However, the entire concept is that the car is moving and in motion the entire time. So wouldn't the car make the motion camera trigger and record? I'm curious. I don't understand. So like I said, I know this is in reference somehow about the taillight, because if she hit John O'Keefe, wouldn't her taillight be broke from the second that she impacted John O'Keefe when she dropped him off, and therefore it would be broken from that point forward? And so there's going to be a lot of talk about different cameras and different people looking at this taillight. I have yet to understand, because I'm too unfamiliar with the case, what camera he's talking about or whatever. But me and you have enough common sense to know when the defense is stating that the camera literally shuts off, or we're missing 42 minutes of footage, and then the prosecution comes up and says, yeah, well, it's because it's a motion sensor camera, right? And the defense says, yeah, but it's a moving car. You're like, okay, where's the footage? So I know right now I want to see this footage, and if 42 minutes of footage is missing, that would be showing us that tail light. Why would it be missing? That's my question. Like Marjorie Holloway says, how convenient, right? Exactly. Jennifer Swain says, I support the blue, but there are bad apples in every profession. Amen, sister.
5:08, between 5:08 and 5:50 p.m. And just to be clear here, we never get to see the condition of the taillight when it's brought into the garage. When we do see the car, we see it after Brian Higgins, Chief Berkowitz, Michael Proctor, and Yuri Buchnick have all had access to it. At 5:36 p.m., the car pings that it's arrived in the Sally Port. That's during the missing video. Trooper Proctor, Trooper Buchnick never sees Brian Higgins' phone. They speak with him, and he takes it upon himself to use his own resources, Brian Higgins, within the federal government to ask a friend, Special Agent Mac Kelch, to download only the text messages in his phone between Karen and him and John.
That's weird. Anytime there is an investigation in a homicide, I don't care who you are, I don't care your reason, but if the investigators say to you, can we see your phone, please? And you're like, hey, wait a minute, I got a friend that works for the feds. I'll allow him to download messages between the victim, the driver, and myself, and that's it. I don't want any of my other information out there at all. To me, what gives you the right to cherry pick what information is handed over? And then, I think if I'm following the story right, the defense is about to tell you that after this information is cherry picked and given to the investigators, to the best of my knowledge, he then pulls the SD card out and destroys any way to double check what the other messages were. And my question would be, was he calling one of those Brians that may or may not have, like it's being alleged by the defense? Was he in contact with him? Because allegedly he does not respond, even though he's a first responder, to this call. Like somehow he just doesn't show up. It gets convoluted, you guys, but here you go.
And that's it. We have to take his word for it that we got all of them. And we certainly don't have any communications between him and Brian Albert, for instance. On February 10th, when he shows up to his interview with Troopers Buchnick and Proctor, he brings with him copies of the text that he has deemed relevant in their murder investigation. And he hands them the copies of the extraction that he had his friend do. He then calls Matt Kelch the weekend of this.
Not me. I'm not the one. Not today, Dave. Not me. I'm not doing this.
The tests, despite the fact that it was done by a friend of his in the federal government. During the federal proffer, Brian Higgins admits that he had been served with a preservation order, and the Commonwealth told him he could destroy his phone despite the order.
Now, destroy was not used because I heard this part with the judge talking to this gentleman, the defense attorney. What was used is he could get rid of his phone, according to the Commonwealth. Even though there were federal investigators, from what to the best of my knowledge, were saying, we want a preservation order on your phone. We want it saved as evidence. But the Commonwealth, which is the other side of the coin of the defense, right? The prosecution side, the Commonwealth, they're the ones that told this dude, hey, now this is what the defense is alleging, okay? You can get rid of your phone. And so that's, here you go, which is super red flag. Like, what in the actual, what?
He then drives to a military base on Cape Cod, opens his phone, breaks the SIM card, and throws the phone away. And he says that he discussed destroying his phone with Brian Albert. Brian Albert also destroyed his phone.
So the Bryans were getting rid of their phone, and the person that they called at 2:22 in the morning and talked for 22 seconds after John O'Keefe would be laying in the lawn with snow falling on him at that time. Not only does he deny that he called the dude, but then he destroys his phone. They both do. They both destroy. Lord. Why would you destroy your phone if you're innocent?
And Brian Albert said that he had received some text that concerns him as an explanation. And after that, Brian Higgins changes his phone number and changes his cell carrier. In short, he was present that night. He had a motive, and there is plenty of consciousness of guilt cover-up evidence with regard to Mr. Higgins. Moving on to Colin Albert. Shortly before January.
Now, Colin Albert, which all of this is to the best of my understanding, which do not quote me, y'all, because I'm just learning the case. I'm trying to share it with you. But Colin Albert, I believe, to the best of my knowledge, is the one that the prosecution is stating left before John O'Keefe arrived. However, the defense is holding fast, saying, no, he didn't. He was actually there. So we're going to have to wait till trial and let them battle it out and see what the evidence is, what are the alibi witnesses, and so forth. And why is the defense so confident that they can prove that this guy, Colin, actually was there when the prosecution is saying, no, he already left before John O'Keefe and Karen Read even got there. All right?
January 29th of 2022, Colin Albert lived with his parents, Christopher Albert and Julie Albert, on John O'Keefe's street, just 2 doors down. We have evidence of bad blood between Colin Albert and John O'Keefe.
Oh, okay. I'm going to try to speed this up because we've been here a day and a half. Hold on, because this gets weird. So, you're going to hear, as we get more and more into this case, that Karen Read and John O'Keefe went to, I believe it was Aruba on vacation. They had a fight. All right, that's one thing. That's a whole nother rabbit hole. Whole nother rabbit hole, Alice. However, the folks he's talking about right now, the 3 he's naming, one of them, the one he's talking about right now, allegedly, according to the defense, waited till John O'Keefe was on vacation because he was so damn protective of his yard and he just couldn't stand these these neighbors, and these neighbors were leaving beer cans in his bushes, all kinds of stuff he's going to allege. But he is alleging that they literally went over and stood in John O'Keefe's property and took selfies being on John O'Keefe's property while John was on vacation. Now, the defense is alleging that this was done to be like, you're on vacation, in your face, we're on your yard. Now, I have no idea what the intent of the pictures were. So we're just going to jump ahead all this. There's allegedly bad blood, okay, between, this is the second person he's naming, and John O'Keefe, okay? So I jumped it ahead quite a bit.
One guy. When John O'Keefe and Karen Read were vacationing in Aruba over New Year's Eve 2022, the Alberts, Christopher and Julie, taunted him. They went to his porch and they had photos taken of themselves drinking on John's property when he wasn't there to do anything about it, evidencing they knew how upset he was at what Colin Albert had been doing. Now,
how do we know? I mean, that might have been kind of, okay, I've just got to play the advocate here for a different point of view. All right, so your friend, let's say it's a friend, is on vacation. You're house sitting for him. I'm not saying that happened. I'm just saying, what if you're house sitting for him and you went and took a picture with your husband with a selfie in their yard to show the house is still standing? I don't know. Could that be? I don't know. But the defense is going to have to prove that this bad blood exists, because I can't believe that anybody's dead because somebody didn't like the way a neighbor was about their yard. That's weak to me. I'm just saying, that's my humble opinion. You know, if they really were standing in that yard taking a selfie going, in your face, John O'Keefe, we're in your yard, you're in Aruba, you can't do nothing about it, then that's pretty much going to look really bad for the Andrews, right? Or whatever their name is. However, we don't know the circumstance. We're hearing how the defense is offering at this time. We'll find out much more as the trial happens. Are there witnesses that there was bad blood, right?
the investigators in this case, Your Honor, including Michael Proctor, kept Colin Albert's name completely out of the police report. When this case began, I had no idea who Colin Albert was. I received the tip right from the jump that Brian Albert and his nephew had beaten up John O'Keefe. I didn't even know Brian Albert had a nephew at that time. But after receiving the tip, I learned of the conflict that Colin Albert had with John O'Keefe, so I sent a letter to Mr. Lally, I believe by certified mail. I knew that the DA's office was planning to present evidence or witnesses to a grand jury, and at that early juncture, before anybody had asked them to indict, I notified the DA of 3 potential suspects, the ones that I'm talking about now: Brian Higgins, Brian Albert, and Colin Albert. After he received that letter at our next court appearance, I'm sure Mr. Lally can confirm this, he acknowledged that both Brian Albert and Brian Higgins would be testifying or had testified before the grand jury, but he questioned why I included Colin Albert in my letter. He told me at the time that he had no evidence that Colin Albert was there that night. However, after receiving my letter, lo and behold, multiple witnesses testified that Colin Albert was at 34 Fairview the night of January 28th to 29th. And now.
So what I'm picking up is that originally Colin Alberts was saying he was never there. And then witnesses came forward and testified in other, maybe in the bed trial, I don't know. But somehow they testified, because he used that word, that indeed they saw him. And now he came forward and said, oh yeah, I'm there, but I left before John O'Keefe got there. So that's Colin's. That's the story. Now, Louis Jeffers says Scott, the DA's office via the victim support person, okayed if even though there was a court order to preserve. Okay, so Scott in the DA's office. All right. And then Jennifer Swain says there is so much reasonable doubt, in my opinion. right? Susan Roscoe says, what's the name of the ex-sheriff that allegedly is involved? Anybody know? I don't know. I don't know that yet. Teresa says, missing video from the route Karen would have drove. Ring camera from the house across the street. Another city council official just didn't record that night. Right? That's weird. Super red flags. Super sus. Louis Jeffrey says, Julie, in her screaming rampage, put the three in the basement with John, the basement that was later ripped up not once, but twice. She goes on to say, his name is escaping me at the moment, talking about the sheriff. He was with the car and just happened to drive by the house hours later and found the first of the taillight. Interesting, right? Okay, my lovelies, here we go.
The DA will argue, I'm sure, at trial that he left before Joan O'Keefe arrived. We don't find their evidence compelling. We don't accept it. We are not required to accept their theory of the case. We're entitled to present a defense. His presence at 34 Fairview gave him the opportunity, along with the motive, to harm John O'Keefe. With regard to Brian Albert, Your Honor, this is a well-connected, well-known, powerful family in the town of Canton, Massachusetts.
And I believe that is a big part of a lot of these situations. Money and power. We look at the Sebastian Rogers case. We have a stepdad with a family that's got a lot of money and a lot of power in Gatlin, Texas, or Gatlin, or however you want to say it. Gallatin. There it is. When you go to the Idaho 4 case, we have the college with the university, and we got Mr. Green Jeans over there, the president, who's a billionaire. And we all know that he's trying to do another college buy, and he's talking about $6 million on the line. So he don't want to look like he's got a bad reputation, and he sure don't want a red rum house showing up off campus right by his little college that could taint that $6 million deal. So is this a powerful family that has been part of the, boys in blue for lineage and after, nepotism? In other words, his uncle, his dad, his grandfather, great-grandfather, all in the system as officers. Something went down. There was something prejudiced or perhaps jealousy or some sort of aggression that they felt towards John O'Keefe. Did they take him down in the basement? Did they beat the crap out of him? Did the dog attack him? And did they go, oh, well, hell, let's just throw him out in the yard here and make it look like Karen Reed, the girlfriend, literally, we'll just say she backed over him. Now snow's fallen. I mean, if Karen Reed actually hit this guy, why would there be people destroying their phones? Why would the cadaver, not appear more mangled, I guess? I know that's horrible sounding, but more mangled at the waist height where the hips would be. Because regardless of what kind of vehicle hit you, you would think that the bumper would make the first contact to me. And I don't care how tall your vehicle is, your bumper is not going to be as tall as somebody that's over 5 foot, right? And do damage to their head or their arm. I don't understand. Where's the damage to me that should be all along the rib cage, the pelvic? I would have expected a leg possibly mangled, but I'm not seeing any of that type of damage. Now, I'm not an expert. I don't even claim to be one. But I, by golly, got enough common sense to know that when I've hit a deer in the past, the rack of the deer wasn't really messed up. The head wasn't really messed up. Now, I had someone back into a pool and I had another person back into another car, and in both scenarios, backing up, the bumper made first contact. And I would go out and I would look at Karen Reed's vehicle logically, and I would measure that bumper, and then I would see how far that would reach up on the cadaver and see, is there damage there? And if there isn't, it really makes me wonder, why? How do you get away from the damage to that part of the body? The phone thing is 1,000,000,000% sus to Az. Hey, Az, lovely. Scott Perkins says, yeah, dog bites on the arm and Google search brings doubt. Google it. I don't know if it's a dog bite or not. I just find it strange. I know a lot of experts are going to be testifying on all of this. I can't wait for trial to really understand it. Unless the vehicle is a monster truck, says Mr. Ifs. Right. Right. And it's not. It's an SUV. All right. Let's continue.
Brian Albert was present at that home when Colin Albert was there. Colin Albert is a member of the Albert family. He's nephew of Brian Albert. We have evidence that Brian Albert had expressed hostility toward John O'Keefe as well. And we know that he initiated a phone call with Brian Higgins at 2:22 in the morning. He reached out to Brian Higgins. And then he picked up the phone when Brian Higgins came back, and they spoke for 22 seconds. And they never revealed any of that to investigators. Again, consciousness of guilt, and perhaps most of all, Brian Albert is a first responder. He is duty-bound to help somebody who's in trouble. He was notified that John O'Keefe was in trouble. Brian Albert stayed in his home. He knew what was going on outside. His sister-in-law was out there, civilians, medical personnel eventually arrived.
All right, so what he's saying is that this guy that's a first responder received a call, this is what the defense is alleging, at 2:22 from one of the Bryans over there at the Alberts, right? His best friend receives a call. This best friend is a first responder. The first responder's own sister or sister-in-law and friends are all over at the site. He's not showing up. And then later he destroys his phone and says, no, I wasn't talking to nobody all night. I never talked to nobody. And then they find out, oh, hell yeah, you admitted, you completely left out that you were actually talking to one of the Alberts over here at 2:22 in the morning. Around the same time that the defense is alleging that a female from the house, one of the Albertsons, Googled out of the blue, this is what the defense says, that they Googled out of the blue something along the lines of, how long does it take a body to freeze outside or hypothermia to happen? I'm paraphrasing. Feel me? So was it like they wanted to know how long before it would be reported? But then if you go listen to the prosecution, they allege that Google about that, the prosecution is alleging that took place after the body has already been found, and that it was prompted by Karen Reed herself, I believe, is what the prosecution is alleging, for her to Google that. So this is all got to come out in trial. We're going to have to hear both sides. But this is intense. Do you feel me? There's a lot here. There's, like I said, there's like scandalous, if you will, like, how do I want to put it? Like people behaving a little promiscuous, is that the word I want to use? Like affairs, like flirting and weird stuff going on. That's kind of concerning, right? Because what if Karen Read was flirting with one of these dudes, these Bryans or something like that, and they decided to get rid of John O'Keefe? I don't know. Or maybe they just harbored resentment to him. I don't know. But the prosecution's saying, no. Karen's making all this crap up. We've got experts that are going to testify that basically say that this cadaver does match up to this car accident theme, to this scenario. And we're basically going to testify and have people testify that Karen was sloshed and that she was mad. And you're going to hear really bad things and really bad calls if they share it. Where when he doesn't show up at home, she gets on the phone and blah, 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 blah. And yeah, like the month or so before when they go to Aruba and Karen Read and John were on this trip or whatever, family even witnessed terrible fighting. So this was not a relationship by any means that I can see that was going well. So I could be wrong, because when you look at what they're saying, or at least what I've heard so far, is all the cameras that were in the bars that they were visiting before they went to the after bar party at the Alberts and this horrible incident took place, it looked like everybody's happy. Like Karen and John were getting along just fine. So who the hell knows? Is it possible that Karen Read exploded when John didn't want to go home with her? Maybe she was jealous. And, if she's drunk, maybe she did call him up and be like, where the hell are you, you loser? I don't know. I have no idea. I haven't heard the calls. And will we get to hear the calls? Because it's all going to be in trial. They're sorting out what we're going to get to hear, what we're not going to get to hear, what the jury's going to be allowed to know, what the jury's not going to be allowed to know. And I believe they have this, to me, I think they're trying to place 16 jurors, with 4 of them still to be picked as far as I know to this day. But it's supposed to start on Monday. And that's what I know as of now. So I'm going to continue and let this roll for you.
He did nothing. That is also consciousness of guilt. Now, Your Honor, with regard to all of that third-party culprit evidence, to admit it substantively, which I would assert to the court is both overwhelming and powerful. With regard to the Bowden argument here, the police investigated none of that. That didn't come from the Commonwealth. They had a complete lack of curiosity as to what was going on in that house that night. They did.
Okay. He's making such a valid point. I don't care who you are. You have a dead man laying in your yard, and they do not investigate that house as law enforcement? Nothing? Didn't even investigate the house at all. How many times do we hear this? How many times do we got to hear that? It's a crime scene, but they absolutely failed to investigate it. Why? What are you afraid you're going to find? How are you not curious as to where the glass came from that's allegedly broken right there? How do you know that glass didn't have something in it and that it came from the house? I mean, really good points by Melanie Little, the attorney. Go check her channel out. She did some really good points about that.
Didn't care. Investigators never went in. The feds investigated, and that's where we got a majority of this evidence. So, to the extent that the Commonwealth now claims that they didn't have notice of this, I beg to defer. They got notice of this when we got notice of this. The Finney case, Your Honor, again, I'm well familiar with it. It stood for the proposition that, if you want to point the finger at a third-party culprit, you've got a constitutional right to do that. And if you want to point out inadequacies in a police investigation, you have a constitutional right to do that. It is for those reasons that I ask you to deny the Commonwealth's motions.
Okay, thank you. Any response, Mr. Lally?
All right. So you heard the judges. Right? She was like, I'm so glad you're done. Right? I didn't like that. She also had a couple sighs during the defense's explanation that she claimed that she needed to hear so badly. All right, now we're going to hear from the prosecution. So let's understand what the prosecution's saying. Now remember, this is not trial. These people are not testifying. They are sharing their views, their opines, their opinions at this point. We have not heard or seen any evidence to back up the claims at this point that the defense is making, nor are we seeing the claims that the prosecution is making. So let's try to be fair here. And we're going to switch over and we're going to listen to about 6 minutes, I believe, of the prosecution's rebuttal.
Briefly, Your Honor. Just first, again, what
Okay, I know there's going to be people that are going to hit me for this. They're going to be like, why do you keep pausing it? I got to tell you, the entire time this Commonwealth guy is up here, all I can think about is Ghostbusters and the little tiny guy that gets all turned into the dog, the mad dog that's up there. And that woman's like, are you God? Right? He looks just like that guy to me. I don't know. Maybe it's a tie. Just had to let that out. Kim Howell says, you know, Mama D, this is all very questionable. But for some reason, in my gut, I felt Karen Read had something to do with this. I'm not saying she did this, but I just have a gut feeling, in my opinion. And you could be right, Kim House. I don't know. I'm very much looking to see what I think. Like, I want to start off with the trial and come on, and every time they do a day of the trial, I'm going to come on and we're going to talk about it. I'm going to stay with this till this trial is over. I want to understand, and I want to be there for every part that we can get to understand what is decided, what is presented. And I don't know. I just got to walk this path, this journey, and understand what all can I learn from this.
the case law requires is evidence and not just mere speculation, or saying that you have evidence is not actually evidence. I do find it somewhat interesting that Mr. Yannetti wrote apparently 4.5 pages of notes, but didn't have time to write a motion to admit the evidence.
That's a good point by the prosecution. You can write 4.5 pages of a note explaining everything, but yet the one piece of paper that the judge requested, which was in writing, you couldn't do that so that it met her follow-up and she was able to process it a little bit. I don't understand why. I hear it all the time. Well, the defense will say, and this is in many different cases, well, if you actually need it in writing, I can put it in writing. And it's like, why didn't you just put it in writing and save us all a headache? I don't know what the deal is. I'm not a lawyer, though.
That he claims that he has. He references in regard to third-party culprit, Dr. Sheridan, who indicated that the injuries are consistent with the fight. He's the same doctor who indicated that the injuries on Mr. O'Keefe's arm were consistent with the dog bite, which was then refuted by the DNA findings from UC Davis, as well as the fact that the injuries are only on one side of the arm. And last time I checked, dogs have teeth on the top and the bottom, and there's no injuries to the bottom.
Well, he really doesn't understand a dog bite, does he? Because they don't always clamp on to both sides of the arm. They actually, as we heard from the expert, can bite and just grab a pinch part of that skin and clamp together with those teeth. And that, like he explained, can be all in one little area where it's a bite. And with all the padding of a long sleeve shirt and so forth, we don't know where those teeth would have landed. The bottom ones could have got caught in the clothing, and then they come almost together before they clamped into the skin. So I don't think that this guy is doing anybody any favors and making light that it could be a dog bite. Okay, because he obviously is nothing but a Commonwealth prosecutor and has absolutely no training, nor do I, about a dog bite. So I think that's kind of a waste of time for everybody, is to listen to his opinion and almost mock the defense. I don't feel that's a great idea on his part.
Mr. O'Keefe's arm. Furthermore, the counsel references the federal grand jury materials, in which I would say, as has been done numerous times previously, is severely mischaracterized as to what they actually contain. And it's not a crash reconstructionist, as it's been alleged here before. It's a biomechanical engineer. And essentially what they did was take painstaking lengths to go to determine that the defendant's vehicle did not strike Mr. O'Keefe in the back of the head, which is simply something that no one has ever said, intimated.
Okay, so then if the vehicle did not strike the victim's head, and you're from the Commonwealth, right now Mama D is like pulling a Nancy Grace here, you guys. Excuse me, sir. Excuse me. That is where the injuries are, factually, as well as on that one arm. But on the victim, on John O'Keefe, the officer, is his head. So how can you say that nobody is opining or putting out there that Karen's car hit his head? Where'd all these injuries come from to the man? Help me at this moment. Susan Roscoe, especially if it was his dog trying to save him, how deep were the bites? Good question. As says, I'm sure I'm not the first one here to suggest we compare Mr. Chris's dog bites and these. You are the first, and we might have to. Louis Jeffrey says, interior, you're talking about Chloe? She was what is called a washed out, not up, washed out police dog, is what we think, right? A washed out, not washed up, right? Okay, let's continue, you guys. There is so much to this case. We have only skipped a rock across the ocean, as the ocean is this case.
At any point ever. There is also a medical examiner in the federal materials who concurs completely with Dr. Scortibello's findings as it pertains to the cause and manner of death. So, with regard to each of these, the other thing that I would point out is counsel was counsel record with the Finney case. The Finney case relates to third-party culprit under the Bowden event, so it's not applicable to what counsel was arguing. It is a low standard, but it's also one that the defendant here has not met. It's not one without limits. As it pertains to much of the material that it was summarized as far as speculation as to what different things counsel feels mean from various things regarding Mr. Higgins, Colin Albert, and Brian Albert. Just starting with Colin Albert, because that's frankly the easiest. He wasn't at the house, and that's what the federal materials confirm with each of every single of the witnesses that were spoken to by the district attorney's office or the troopers or testified to the state grand jury. They testified to the exact same things in the federal grand jury, that Colin Albert had left the house prior to the defendant and the victim arriving there, and there's absolutely nothing to combat that whatsoever, other than, again, just rank speculation. So opportunity would be a little bit amiss if he's not even there at the same time as Mr. O'Keefe, regardless of the invalidity of any sort of ill feelings or ongoing feud that's purported from whatever unknown evidence counsel claims to have. In regard to Mr. Higgins, that was a fanciful story, but again, there's actually no actual evidence of most of those things, or at least the imputations or the connotations the counsel wants to put behind that. Whatever he feels things were observed. So Again, I'm not sure where the evidence from this is coming from. What I'm also a little confused in regard to is that if counsel is merely relying on materials within the federal grand jury and just learned of them at that same time as we learned of them when materials were provided pursuant to TUI, then it's a little peculiar that the exact same arguments were being made throughout the pendency of the case well before counsel was provided with any of those.
Okay, you lost your point, sir, because they did not say that. I heard it myself, and so did all of our listeners, that they said most of. So just because they shared something that they shared before the federal investigation doesn't mean that you need to throw a jib in, because that had absolutely no weight. No weight at all. Let's give him a little bit more. We'll kick him ahead a little bit because he's really going on. And it's basically saying we disagree with everything the defense is saying. They have the same report as we do. It's a federal investigation. We're not seeing what they're saying. It's a lot of talk, and once we get into trial, we'll be able to prove it all different. So we're going to have to wait and see, I think. But let's continue.
Parked it when they stopped there to see if Mr. O'Keefe was there before then piling into Ms. Roberts' vehicle and proceeding to 34 Fairview. And what you can see within that cruiser camera video at 8:22 in the morning is the damage to the right rear taillight of the defendant's vehicle. Well before the defendant had then come back to the house after the hospital and then gotten in 3 separate cars with her family and driven in a blizzard all the way back to her parents' house in Dighton. And then the vehicle had then been towed from Dighton back to the Canton Police Station by the state police with the assistance of the Dighton police.
Do you know what exhibit number that is before the grand jury?
I believe it's 56, but I...
All right, so we're going to have to pay attention. Note on my whiteboard is exhibit 56. Now, the reason is because allegedly this is going to be evidence that the prosecution is going to bring up in trial that shows that Karen Reed's tail light was allegedly broke, right, at the time of this cam on their dash cam, if you will, of their police car. Now, the question is, when did that dash cam get recorded? What will they be bringing out? But when we get into trial, I am really going to be paying very close attention to exhibit 56. Okay? All right, let's continue. We're almost done. We got 2 more minutes, and then we are done for this afternoon. We run a little bit late. I knew we would, but there's a lot to this case, my lovelies.
I can certainly locate that information. And again, as far as Brian Albert is concerned, I heard nothing other than he's apparently in a well-connected family in Canton, and Colin is his nephew who wasn't present at the house when Mr. O'Keefe and Ms. Reed were present at the house. So again, I think it's a stronger argument, certainly, if we're trying to bootstrap onto a Bowdoin defense, and counsel will probably likely be allowed to at least investigate that as far as impeachment, cross-examination, things of that nature. But there is absolutely nothing beyond just a fertile imagination and rank speculation as it applies to a third-party culprit defense. And for that reason, the Commonwealth's motion to exclude it should be allowed.
The only thing I'd like to correct, Your Honor, is, well, or at least point out, is that, the car pinged at 5:30.
So hold on until you get to the microphone.
Yeah, I'm sorry. The car pinged at 5:36 p.m., indicating that it was in the Sallyport. There is an outdoor camera where you can see the car about to enter the Sallyport at 5:31. Of course, you can't see the tail light in that outdoor, camera. But Mr. Lally just argued before you, well, the reason why there's no, video of the car between 5:08 and 5:50 is that it's motion activated. And I just ask the court to use common sense here that if the car's entering, and by the way, the car's there at 5:50 with a couple of people around it.
He's talking about that missing footage, all right, that I was talking about earlier. He's saying, 48 minutes of missing footage. that would have shown if that taillight was broken or not while it's being put through custody. The car is in motion, right? Here he goes. He's talking about that missing footage.
When the camera comes back on, you see the car. So unless it was teleported in a split second so that the interior camera would not pick up motion, it drove into the Sally port. I believe that's the definition of motion, and it should have been picked up, according to Mr. Lally's own words.
Okay, so when you walk away from the microphone, it's harder for the court reporter to hear you, Mr. Yannetti.
And I apologize, Judge. It's according to Mr. Lally's own words, it should have picked up the movement.
Okay. All right, so I believe that's the last motion. So why don't we recess until 2 o'clock, and I'll see you back here at 2, Mr. Lally.
All right, that is all we have time for to go over today. But we're going to be bringing it to the table. This is not going to be easy. This is going to be complex. But I feel that this is going to be one of the most vital cases for us to understand a lot more about. Is there some sort of law enforcement that always has their back cover up going on in certain cases? Like I've suspected it in the Idaho 4 case, right? So this case caught my eye mainly because of that, is that there is this aspect of possible, or at least as the defense puts it, police corruption. Well, it definitely attracted the feds to investigate. And as we go forward in this trial, I'm hoping to learn more and more about what the unbiased feds bring to the table. And did Karen Read just get drunk, smashed, get pissed off, and purposely back over her boyfriend? Or was he taken down in the basement after she left, beat up, the dog attacked him, and they threw John O'Keefe out in that yard to cover up what they'd done, as if, Karen had hit him, just to cover it all up? Why sell the house? Why tear the floor up? Why get rid of the dog? Why destroy your phones? Why all the lies and omission about who you talk to in the middle of the night if it's all on the up and up? I don't know, you guys. There is a lot to this. This is going to be a very, very intense case. I'm purposely covering this not only because I've fallen down a rabbit hole, but because this is history in the making. I feel this case is very much going to be something, as I get older, I want to refer back to understand what I learned from it. I feel this is very much one of the few trials where it's being taken serious. In other words, when I covered the Steve Avery case, that was alleged from the get-go that Teresa Halbach, that the police being, that law enforcement being sued by the defendant was being framed in order to stop the payout, in order to stop the lawsuit. Let's just frame the person suing us for murder so he can't pursue us. There you go. That's the Steve Avery case. But it was always like this on the back burner joke that the police might be corrupt. Oh, please, darling, right? Like, I've always believed that they got the DNA right from the damn soda that he was drinking from at the police station. I'm just saying. Anyway, my lovelies, I want to thank you very, very much. I hope this brought you a little bit of understanding of what the major, and like I said, there's so much to this case I don't even know. We have just scraped the surface. But I hope that I have done a good enough job. If you feel like it's something you choose to do, I encourage you, and I am grateful for all the support, whether you hit the like, you share it, whatever you do. I want to say thank you from the bottom of my heart, and I will see you again. Teresa says I'm definitely watching the opening statements on Monday. Well, and good point, Teresa. it reminded me that one thing the judge did say, and that is that the defense is restricted, if you will, from pointing at third party directly or something like that. I'm paraphrasing because I'm not a legal beagle. In the opening statement, I believe. Something to that effect. But I've got so much more research to do, and we'll just have to stay tuned. And a lot more came out today, so I'll watch it all tonight, and I'll try to catch you up and me up to speed tomorrow. Aw, I love you, Susan Resco. Hi, Debbie. Hi, love. I love you to the moon and back, too. Thank you, Mr. Is. Thank you, Mr. Scott Perkins, and everybody. I will give Jack hugs. He needs it. He needs his 11 family. Love you guys to the moon and back.